I'm Paul Morinville. I've got 10 issued patents and another 20 or so pending. Mine are in enterprise software. They make up the middleware layer of big companies. U.S. inventor, we advocate for inventors in Washington. We are inventors. All of us are inventors. None of us are paid. We just got I got a little mad when they wrecked my company. And I started going to Washington. Our goal was to stop current patent reform, which I want to tell you, I believe it is dead. For a number of reasons, but the biggest reason is inventors have halos. And you go into Washington and you're an inventor and you talk to them, you're not paid, you're the real deal, and they listen. If there's any lesson I learned from all of this is you can go and actually change the course of Washington. And Adrian and a bunch of us inventors did just that. We want to go the other way. We want to reverse the bad Supreme Court decisions. I'll go through those a little bit in a minute. We want to pass a patent bill that protects inventors. Right now, the patents are so weak, I can't even enforce my patents. I can't find a contingency law firm to take it. I don't have $5 million, and I can't find an investor. I had both of those until 2013, and they gave me my patents back. They stopped enforcing, gave me my patents back because the patent system is so screwed up. Right now, we've been traveling around the country talking to inventor organizations. I think this is probably number 15 or so of the inventor organizations we talked to. And we're talking to you for a reason. Everyone in here has a halo, and we need your help. We advocate for inventors in Congress, and that's all we do. We're hellraisers. This is the problem. This is why we have patent reform right here. This is an Android operating system. There are 150,000 patents in this cell phone. You could only buy an Android operating system in the last 8 years or so. But Palm existed, Microsoft existed, all of these different phone operating systems existed. Google bought Android, which was a camera operating system, converted it to this phone, used their money and their market power to saturate the market. They now have 84% of $1 trillion worldwide market. And they own the operating system. That's a big deal, and that's what this fight is about. You know, Facebook's contribution to our technology stack is the like button. And they've built a multi-billion-dollar empire on it. They are not technology companies. They advertise themselves as if they are, but they are consumer internet companies. They don't build technology. They do in their data centers. And then they run it under trade secrets, which is a problem because if you don't know what they're doing, you can't build upon it, which is the reason we have the patent system to begin with. I disclose, and you can make it better. They want trade secrets, they don't want patents. They want to keep their place in the world. Retailers like JCPenney, why would they be in it? Well, JCPenney sells stuff, and they get sued. They sell stuff manufactured in China. So they get sued for selling it here. And they don't like that. But you can't hardly sue the ones in China. You can, but it's really complicated. Real estate companies are lobbying for it. Real estate companies don't invent anything, but they use mapping software, and they don't like being sued for using somebody else's inventions. That's where this is from. These are not the people who are inventing. These are the people who have established markets and are making billions of dollars, and they're driving the agenda. So, do you guys know what a patent troll is? Who's heard of a patent troll? What do you think it is?
Basically, you look for patents that have been issued, or you buy up patents, rather, and then if a company is infringing on it, you can sue them.
Yeah, that's exactly what they'd say that is. And that's considered bad because you're not producing a product, but you're suing the companies who are actually producing products, right? And that the argument is slows innovation down across the country. I disagree with that argument. But that's exactly what it is. Or you send out a bunch of threatening demand letters. Or there's another one which I've seen, which is enforcing a patent against a non-infringing product. That's called frivolous litigation. All the rest of that is different, and I'll show you why. So what is a patent? A patent is an exclusive right. I have my patent here, but that's okay. I'm a small company, and you guys are angel investors. You look at my patent as an exclusive right, and with that exclusive right, I can keep big competition away. In my world of enterprise software, I have to keep Oracle and Microsoft and SAP away. All they have to do is upload my stuff on their products, massively upload their customer base, take away my market. I'm out of business. I have to have a patent. And you look at that as protection for me. I have the exclusive right, and I won't be stolen. You also look at it as protection for you. If I go out of business, if these big companies do actually steal my stuff, which is what happened to me, you end up owning my patent, right? So, why do companies go out of business? There's a lot of reasons, right? Bad management team. We went through a whole bunch of the mistakes you can make. But one of the things that happens, unfortunately, is big companies steal the invention and massively commercialize it and take away your market. And in software, that's a big deal. That happens all the time. When that happens, you get my patent. You don't have a product, and you never will, because you're an investor. Your job is not to make products. Your job is to fund small companies and make money off of that. To return that invested capital, you've got a choice. You can become a patent lawyer and sue and live the next 7 years in court, or you can sell it to another company that buys it and bundles it into large numbers of patents, like an Intellectual Ventures or a YLAN or something like that. And when it's bundled, they license the bundle. So they could license 1,000 patents instead of 1,000 inventors licensing one at a time. It's economically efficient. But these patent trolls are being wiped out because they think they're bad. They're not. They are the market, the secondary market that drives capital to small companies. They're your grandma. If your grandma invested in your patents and you lost your company, she now owns it, your grandma is a patent troll. So what happens if you kill patent trolls? You kill the secondary market. That means that big companies can, first, you won't get a licensing deal because they don't need to. You may if you somehow build enough market or some other reasons that they might license it. But if you don't have a patent, you don't own it, which means they can take it and they don't have to pay you. So you become the test market, the test marketing program for big corporations. Patents are really important. And you won't get investment because your investors are going to look at this and say, well, you know, you can go build it and you can go get it out there, and, you know, Hasbro's going to steal it, or whoever it is, I don't know, is going to steal your stuff, and there's nothing you can do about it. I can't remember Abraham Lincoln's quote, but the three most important things ever in mankind, one of them is the patent system. And that's driven our economy, that drives our jobs, that creates our small businesses, and it's pretty damn important.
Wasn't the patent office one of the first buildings in Washington?
Yeah, and when the English took over Washington in the War of 1812 and burned it all down, they didn't burn the patent office. Deliberately didn't burn it. So, where are we today? So going into this, without even having this patent reform, which I'll tell you about, you can't get an injunction. You now have to prove, in my case, these big software companies took my stuff, upgraded their software, massively commercialized it, ran me out of business. I don't have a product. I have to prove that injunctive relief, in other words, stopping them from doing it is in the public good. It's in the public good for me to have to prove that. Well, I can't prove that. I don't have a product. So I can't get an injunction. It is nearly impossible now for any of us to enjoin someone else who steals it. So if you're a big company and you steal it, you keep it. Then, another case, there used to be treble damages. So if I could prove that you stole it, then you would have to pay 3 times what it would cost you for a license. So there was some reason to license it first. Well, they eliminated that too. It's impossibly difficult to get treble damages if somebody willfully infringes on your patents. So first, you steal it, you keep it, and now it doesn't cost you a dime. They've also done a lot to reduce damages. Damages are a fraction of what they were just 10 years ago. They have created incentive to steal patented inventions. If you're the CEO of a corporation, it is your fiduciary duty to steal patented inventions and massively commercialize them and never talk to the inventor unless, of course, you're sued. And then you can litigate that inventor into oblivion, which is what has happened to me, and I stopped all my cases.
Another term for it is patent jacking, I've heard recently. Yes, it does happen.
So the America Invents Act created what they call PTAB procedures. There's a whole bunch of them. You'll hear about IPRs, which are inter-parties reviews. But there's 3 of them. There's CBMs, IPRs, and PGRs. But in a nutshell, what they are is they eliminate the value of a patent. It's no longer a property right. At once upon a time, and for the first 216 years of our republic, a patent was a property right. There's case after case that it's a property right. It says it right on the PTO website, it's a property right. In order to extinguish a property right in America, you have to go through an Article 3 court with an independent judge, lifetime appointed, who has no career. What they've done, and the other thing that had to happen is you would have to be a party to some sort of action against me. If you were a party, you can't do anything about my property right, but you could challenge it. And if you challenged it, it's your job to come up with the evidence that my property is not a property. And that level of evidence is clear and convincing, the highest level of evidence in federal court. That's why property rights in the United States are so powerful. That's why capital is attracted to property. That's why we have an economy in this country. The American Invents Act said, oh, to hell with all of that. All of that. Now, anyone in this room can challenge my patents. It'll cost you $20,000. It goes into the patent office, an administrative court with judges who are employees of the administration who report up through to the president. Then it becomes my burden of proof. First off, that patent is immediately invalidated. I can't enforce it anymore. Any enforcements I had in place will be stayed until it gets through this procedure. Then it's my burden of proof to reprove that the patent is valid. And it's nearly impossible because they don't use the same standard. They use the same standard you used in the patent office to begin with, which is called a broadest reasonable interpretation. To make it simple, they take each word and they make the biggest possible meaning of each word, and they establish this great big bucket, and they dump in prior art. And they are invalidating 85% of the patents they see. And it'll cost you 3 years and $1 million just to get your patent invalidated. It could cost more because they can challenge it multiple times. There are some of these cases that are running into $20-30 million to reprove that you actually have a patent. A patent is no longer a property right because of the American Invents Act. Then, on top of that, this is the one I love. Section 101 of the patent system is the door in. And it says any machine, manufacture, composition of matter, and something else, is patentable subject matter. The biggest word in that whole sentence is any. Any means any, unless you're the Supreme Court judge, because there's an exception to any, and that's called an abstract idea. But they don't define what that is. And if you look at any invention, at the core of any invention is an abstract idea. So once you get through the PTAB, if you're one of those 15, 16% that survives, and you're back in court, then they'll challenge it as an abstract idea. There's another 85% chance they're going to find it's abstract and throw it out. You could get 7 to 10 years into a patent lawsuit, spend $5 to $10 million, and have it invalidated on the last day. There are no contingency attorneys, and there are no investors. That's the state of our patent system today. So what are we going to do? Here's what these laws did. We'll take all that, and we're going to do loser pay. So I go sue a big tech company, and I lose. I pay their legal costs. I got an 85% chance of losing. I got an 85% chance of losing, and it's going to cost me $7 million, $5 million to get there, and then I'm going to pay their legal fees for the biggest, most expensive law firms in the country. I could spend 2 or 3 times that paying them, and it would bankrupt me. Send my kids to, they wouldn't go to college, wipe me out. But that's not all, because they know I could go bankrupt. So if you invest in me to help me go through court, and I can't pay it because I bankrupted, they're going to take your personal assets. The investors' personal assets. It pierces the corporate veil. It goes through to the investor. It takes their house, and they're gone. Now you're going to invest in my patent lawsuit? This is what they wanted to pass. Bonding, because patent trolls are bad. They're going to make you bond just to open the courthouse doors. You're going to bond for the losing side, which could be $5, $10 million, at an 85% chance of loss. And if you do insurance, I'm not an actuary, but if I'm going to sell insurance for an 85% loss for $5 million, I'm going to charge you $5 million. It's going to cost you just to get the judge to accept the pleadings, $5 million. Then the other thing, this is where JCPenney comes in. JCPenney, this wonderful little company that doesn't want to be sued for selling stuff from China, wants a customer stay. So if you sue JCPenney, they get to pull out the trump card. I'm the customer. Sue who I buy it from, and they're in China. So now you go to China. And you may end up with multiple different countries where this product comes from, and you might be in multiple district litigation across international borders dealing with trade things like TPP, and you're just never going to be able to pay for it. One, it's going to take you the rest of your life to get through litigation, and the other is you're going to be spending dozens of millions of dollars trying to figure it out. So they get to pull out this little card that says you can't sue me, and away it goes. That's why JCPenney is for patent. Okay, so this is all dead. We killed it. And we killed...
Why we knowledge. Every month we've been telling these people this is what's at stake and this is what's happening, and so I'm really proud of the fact that as a grassroots effort, we were able to push this bill back. Again, big thanks to Paul here. So
we did it without any money. We did it without any money, except for what we spent in hotels and gas and loss of income and stuff. But we went there ourselves, knocking on doors. When I went to Washington at first, I got pissed off because they killed my company. It's like, what do? You go to Washington. I hopped in my truck. I drove in there. I got a hotel. I got up in the morning and I got a cab, and I said, take me to the Senate. And they said, which building? And I said, what? There's more than one? And he said, yeah, there's 3. I said, well, just take me to the first one, But I had no idea. I had no idea what I was doing. I just knew I was going to do something. Randy Landrino joined me a few weeks later, and we went door to door in the Senate. We generated a filibuster, and we killed it in the Congress, 113th Congress. Then it came back, this last Congress, and we went to the House, and we sat in 350 House offices, and we turned them one by one. They're trying to now break this apart into its individual pieces and pass them individually, but I'm fairly certain that none of this is going to pass the House. I think inventors own the House. I'm not certain. I'd like to say that 100%, but there's always a possibility it's Washington, right? Okay, so we changed the discussion. The discussion now in Washington is no longer these evil investors or patent trolls. It's now the plight of inventors. What's going on with inventors? The discussion there has changed. We are in position now to change it back, to get our country back, to get our economic engine back. We have more companies going out of business today than we have starting up for the first time, certainly since the Great Depression, but possibly since the beginning of our country. And one of the primary reasons is the destruction of the patent system. So we need, the reason I haven't been home but 2 weeks this entire year is to get you guys to sign up with me, because this is too big to swallow. I mean, how do you understand all of this stuff in a soundbite? You can't. There's too many complicated things. I'm just giving you the highlights. There's more. But we need to speak with one voice across the entire country on individual issues and do it all across the country at the same time. Take this no injunction. The case is called eBay versus Merck Exchange. We need to speak on that issue. We need to go to our politicians. We need to write letters to the editor. We've got some help in Washington. We've got a PR company that'll help us place media from inventors, writing letters that says, hey, you know, what do you mean I can't get an injunction? It says that in the Constitution. The only thing that a patent is an exclusive right. Why can't I have that? But I need people to sign up so that when we hit the issue, we'll send you what we need you to say, and then we need you to make calls to your people, to your politicians, to your local newspapers. We need you to send letters off. We need a hell raising across the country all at the same time, because we're going to capsulate that issue. We're going to name it, and we're going to move on to the next issue, and then the next issue. And we've got congressmen right now who are willing to roll a bill out for us. So we've got A, B, and C sealed up over the next 6-8 months, next year. And then next year we put out a bill that says this fixes A, B, and C, and they don't have to think about it.
Is that Congressman Macy?
Massey will, Coons will. We've got a bunch of them in Congress. This is bipartisan. If you got a political party, throw it away on patent reform, because it's Democrats against it, Democrats for it, Republicans against it, Republicans for it. It's craziness. It's all about money. But also, the hell raising, if we can get this done, will influence the courts. Here's what happens. Patent reform rolled out in 2005, the first bill. And in it had no injunctions. In 2006, the Supreme Court read the bill and said, okay, we'll do that ahead of you, because we don't want Congress messing with the way we do our courts. So they passed legislation. I mean, everybody must have thought that you had to have legislation to change the Constitution. Maybe you need more than legislation. I think you might need an amendment. But anyway, the Supreme Court did it for Congress by passing a bill. Now we got case law. So they had the next bill that came out, and they had the no treble damages for willful infringement. And sure as shit, the Supreme Court jumped on that, passed it again. Even if we don't pass the bill, if it becomes a fait accompli, the Supreme Court's going to pass it for us. We're going to play the same game back. Okay, I got a sign-up sheet down here. Could you, if you're interested, I sure would appreciate it if you give me your email address and stuff so we can get you. We need to spread the word. We got on LinkedIn. I'm most active on LinkedIn. We've got a U.S. inventor group on LinkedIn, and we put out lots of patent reform related stuff, lots of information. You can even, if you've got a product, we let people talk about their product. We don't like to sell it, but tell me how cool it is. And there are several thousand people on it. And then we also on Facebook have a U.S. inventor group on Facebook too. If you could like those, that'd be great. So you can, we can communicate with you.
Do you have any stories about damages, right?
Yeah, and we've got the other thing we've got is one of the lobbying firms volunteered their PR group for us to bring inventors who have had issues with their patents, either a long time. I got a patent that's been there 14 years now. I had hair when I filed that patent. It's still not out of the patent office. So last thing, we just got, so Luann here, the 5'4" giant. So I get this story. This is mine to tell. She comes to the UIA board meeting. I'm on the board too with Adrian, and she was going to do some fundraising for the UIA, and I started talking to her, and I convinced her. I stole her for U.S. Inventor, and she asked me what I needed, and I said, well, I need 100,000 inventors because we need to change this. She said, give me a week. A week later, she calls me. She says, I talked to a production company in L.A. We got a TV program for 2 hours. Where we're going to showcase inventors or celebrate inventors on the early stages. In Shark Tank, you have to have a company and a product and all that stuff. But how do you get to Shark Tank, right? So it's buyers, the prototypers, the manufacturers, the whole story of that. And we've got a $100,000 prize. We've got a patent purchase. We got all kinds of prizes. But that'll be coming up. We just got the production company's pitch deck on it, and we're fundraising for it right now, but we think we got a 2-hour television program. Luann is the one that's running it.
Guys, I just want to say something funny. For me, it was American Idol meets Shark Tank, except that I don't believe in Shark Tank. I think you need purchase orders. I don't believe in getting money until you have purchase orders. I just think that's the way the world should work. So I pitched it to a man who doesn't watch TV.
Yeah, I don't watch TV.
Pretty clue what I'm talking about. So, but fortunately, innovation is really big right now, and the production company really loved it. So it's a 2-hour special. It'll be top 10 contestants. The idea was not only do the top 10 get to go on TV and they get to show, you get exposure, you get to compete for this money. Because there's 50,000 in prototype money, 50,000 towards tooling. We have a purchase order. We have a straight buyout license deal. The deck. But what's really fun is we have about 10 gifts just for entering your product that will be drawn even if you don't make it to the top 10. So the idea was to really show the nation that we can make money off of our products. Okay, that's the ideal, is to celebrate innovation. It was just funny to me because he totally doesn't get TV. So it was like, okay,
I got a lot of books, man. I got books everywhere. Thank you.